All right, good morning, everybody. Thanks for taking some time, or I guess it's afternoon now, but thanks for taking some time today. Um, we're really excited to have this webinar. For the last few months, ESTA has been pretty much the only topic in Lansing. It's sucked up all the oxygen in the room, and there's been a lot of question marks, and thankfully we have some resolution on that now. But there's still, quite a few questions out there about how to implement this now that we have a final bill signed. So with that, we have Jody Schaefer here. Jody is a certified senior professional in human resources, and she's the owner of Human Resource Management Services here in Michigan. She has a bachelor's degree in psychology and education from Kalamazoo College, and over 20 years of experience in human resource management. She was recognized as one of the 10 over the next 10 in the next generation of business leaders by the Lansing Regional Chamber. She was also accepted to the MSAE Association Choice Award on behalf of HRM for the consulting services category. She sits on several statewide committees focused on human resource policy and leadership development. She's a regular contributor to various industry publications and an author of a ready-to-use HR system for small employers. She does speaking engagements and training seminars on all aspects of human resources, including employee relations, leadership skills, performance development, onboarding, recruitment, retention, and much more. So with that, thank you so much for being here today, Jody, and we'll give you the floor.
Okay, wonderful. Thanks for having me. Few housekeeping notes before I jump in. One, I want to introduce my colleague, Alyssa Parks. Alyssa's going to be joining me on today's webinar and moderating some of the Q&A. And so you'll notice on this webinar, we have disabled the chat. We want to push all of your questions to the Q&A function, so please utilize that. Alyssa will be monitoring those, and the ones that she can respond to in real time, she will. The others she will hold, and I'm going to pause about 2/3 of the way through the presentation today, bring Alyssa back on the screen and go over some of the common questions that have been asked thus far, and then we'll wrap up, and we're scheduled to end today at 1 o'clock. We are recording this session, so that will be shared with all attendees afterwards if you want to hear me say something again. I'm also going to be sharing a copy of my slides as well as some resources. So if you're attending today's webinar, you will also get a copy of those. So some things that I'm hoping to cover in our hour together, a quick timeline of kind of how we got to this point. And then I'm calling this ESTA 2.0. I'm actually totally stealing that. That's not my moniker. That's Wendy Block from the Michigan Chamber. And that's how she's been differentiating between the original ESTA language and the revised ESTA language. So I'm just going to stick with that. For those of you that have heard Chamber webinars, I'll use the same terminology. So key components of the revised language and some implementation considerations, again, and resources that we've created, free resources to help guide you so you're not starting from scratch here. So a quick reminder of how we got to this point. I know many of us were, looking and thinking about ESTA long before February of this year, and that's because in July of last year, the Supreme Court in Michigan ruled in favor of mothering justice, which basically said to all employers in the state that we would have to offer earned sick time in accordance with the original language of that ballot initiative. And we had an effective date of 2/21/25 to get into compliance. Now, we were hopeful that the current legislature would make some amendments to that law as it was written before the effective date, because it was problematic in various areas and going to be very difficult to comply with. But the legislature, up through the end of last calendar year, did nothing with it. And so on January 8th, when the new legislature was sat, we now had a split chamber. We had the Senate, which remained democratically controlled, but the House was now a Republican majority. And there was a real question mark over whether a split chamber could come together on a compromise around amendments and whether they could do so in such short order. On the 8th and the 9th, both chambers introduced their own amendment bills, which was great. That I think signaled to all of us in the employer community that they were serious about this. But again, we were very concerned about the short timeline. And, you know, it was like 11th hour, it was actually 12th hour, because on the actual effective date in the wee hours of the morning on the 21st of February, that is when the bipartisan compromise was reached. The amendments were signed into law on the 21st, which made it problematic and a bit chaotic for employers. So now here we sit, it's post February 21st. And for those of you that have 11 plus employees, your compliance deadline has come and gone. But we had a 30-day window to basically get written notice out to our staff about how we were going to make sure that we were in compliance. So for many of you, even if your compliance deadline was the 21st of February, a lot of you are kind of looking at the 23rd of March, which is the 30-day, the end of that 30-day window when you've got to get notification out to your staff members. So some of you are still probably in the throes of figuring out what you're going to do and how you're going to do it. So that's where we're going to spend some time today. I'm going to go through some of the key provisions of this revised ESTA Act, and then we'll talk about some implementation pieces as well. Remember, if you've got questions as we go here, you can use the Q&A feature. I am going to cover a lot of information today, so the likelihood that I answer the question you have is probably pretty high, but it is there for you if you need it. So some of the basic components. I like to break this down into questions. It seems to make more sense that way for folks. So first question, who has to comply with this? And the answer, all employers that have folks working in Michigan. So even if the employer is actually physically located in a state other than Michigan, if some of their staff are working in Michigan, or if they have a remote employee who's working in Michigan, then that employee would be covered under earned sick time. The only exceptions to this remain the federal government, railway workers, and employers covered under the Railway Unemployment Insurance Act. I have no idea what that is, but apparently there was kind of this federal exclusion, and it was in the original act as well. So for all intents and purposes, if you're not the federal government, you are having to comply with ESTA, even the amended version of ESTA. Even if you're a nonprofit, I know there was some question early on when those amendments came through whether nonprofits were excluded. They are not. Everyone has to comply. But the next set of questions is by when, and there was a change here. And what you'll notice in these slides is that anything that I've highlighted in yellow is a change from the original language, just so you can kind of keep track. But the by when do you have to comply is based on size or whether or not you're a new business. And I'll define that in just a moment. So for those of you that have 11 plus employees, your compliance deadline is still the 21st of February, which, as I've said, has come and gone. If you have 10 or less employees, and this is slightly a change because the original act said less than 10, which meant 9. But in this case, the revised language says 10 or less. If that's the case for you, then your compliance deadline is October 1st of this year, meaning that's the date you have to start complying with the rules, and that's the date that your accounting or accruals would begin. And then there's this third category, which again was a revision, and it has to do with new businesses. Now, a new business is defined as an entity that did not have an employee on payroll prior to February 21st, 2022. So if you didn't have an employee on payroll prior to then, your compliance date is based on date of hire of your first staff members. So you get a 3-year grace period from date of hire of your first team member. So if you hire your first team member today, March 10th, 2025, you wouldn't have to comply with ESTA until March 10th, 2028. So it's 3 years from the date of hire of your first employee. Okay. Next set of questions, who counts as a covered employee? Not much has changed here. It's most of your staff will have to become eligible for ESTA, again, assuming they're physically working in Michigan. So if your business is stationed in Michigan, but you have remote employees working in Ohio or Indiana or something like that, then they wouldn't necessarily be covered under ESTA unless you chose to just cover everyone. But anyone who's physically working in Michigan must be covered regardless of hours or status. So full-time, part-time, temporary, seasonal, exempt, non-exempt, etc. That's not a change, right? But the new amendment did give a few carve-outs. The first you know about, you've heard about, and that's independent contractors. By and large, those folks that you're paying on a 1099, if they are truly independent based on the economic realities test, then they would not be covered under ESTA. Same with your vendors. But there are a few other categories that didn't exist previously that now do in terms of exemptions. The first, unpaid trainees or unpaid interns. If you have anybody that meets that category, they do not have to be covered under ESTA. May still have to be counted potentially in your head count, depending, but not paid under ESTA. Another group, individuals who are employed in accordance with the Youth Standard Employment Act. These are generally folks that are 17 years and younger. And the in accordance with Youth Employment Standards Act means that if you have youth in your workplace and you're following the rules for them, meaning they have a work permit, they're not working beyond the hours limitations when they're in school, they're not performing hazardous job duties that OSHA would say they can't perform. As long as you're following the rules with your minors, they do not have to be covered under ESTA. And then the third one that I think we're still waiting on some clarification from Leo on, those who work in accordance with the policy that basically allows them to schedule their own hours. And there's no negative employment consequence if they don't schedule a minimum number of hours or schedule no hours at all. This one is still a little bit nebulous. When I was talking with Sean Egan last week, who's the head of Leo, they were waiting for further clarification from their legal team on what this meant. His assumption at the time was that this would be a very narrow exemption. Because I was throwing things at him like, what about, if you have a substitute list, like in dental offices, they'll have sub lists for their hygiene employees. And if the hygiene worker can't come in that day, they'll just pick a name off the sub list and see if they can fill in. I don't think those folks are probably going to be covered under this. So we'll see. We're just waiting for Leo's updated FAQ on that. But that's another carve-out category. As I said, this is just kind of more on that, and we're just waiting to see here what that means. So next question here, and this is where it's going to start to get, you're going to see a lot of yellow on the screen, okay? Now I'm going to explain earned sick time initially as if it was a standalone bank of time. And then I'm going to talk about what happens if you decide to fold earned sick time into an existing time off bank, whether you call it PTO or, personal time or whatever. So just initially keep in mind, I'm going to explain this as if it's a standalone bank, okay? So the question is, how much do I have to give? This hasn't changed, 1 hour for every 30 worked. Remember, it's 30 worked, so you're not going to include pay that might be in their check for a holiday, pay that might be in their check for a vacation day. Those kinds of things aren't going to count as an hour worked, even though it might be an hour paid on their paycheck. So it's 1 hour of ESTA for every 30 hours worked. One change here in the revised language is that ESTA can be used in 1 hour increments. The previous language said the smallest increment of time that your payroll system could track up to 1 hour. And so that was going to be a real nightmare for folks because most timekeeping systems can track time in 1 minute or less increments. The revised language flipped it and made the 1 hour increment the default. You can't require folks to take ESTA in more than 1 hour increments. If you choose to allow folks to take it in less than 1 hour increments, that's fine, that's your choice. But the standard is 1 hour. Okay. So let's look at two different options for how I can provide this ESTA time. The first is the accrual option. This is the earn as you go option. This was the one that was pretty clearly spelled out in the original language. So if you decide that you're going to have your team earn ESTA as they go, then it's an accrual rate of 1 hour for every 30 worked. We know that. And for your folks that are exempt, you can assume that they're working 40 hours a week. And so you can just put 40 in for every single week across the year and base your calculation on that. If you have exempt staff working less than 40 hours a week, you can adjust that average rate down. So maybe I only work 32 hours a week, or I'm a salaried employee working 25 hours a week. Then my schedule would be 25, 25, 25, right? So you can adjust that down if needed for your exempt staff. One thing that's a change for the accrual, previously there was the allowance for a wait period that folks had to begin accruing on day one, but you could have them wait up to 90 days in order to use or access that ESTA bank. For an accrual system, you can still have a wait period if you want, but it can only be for new hires. It can't be for anyone that was on your payroll as of the effective date. And now it can be up to 120 days rather than 90. And it sounds like that was done to create some allowances for seasonal employers. If you've got you have 3 or 4 months to kind of earn all your money in a given year, those seasonal folks would still be eligible, so to speak, for accruing the ESTA time, but with that wait period, they may not be able to actually access any of their accrued time before the season ends. Okay. With accruals, you now have a choice in terms of carryover. So with an accrual system, an earn as you go system, your choice is at the end of the year, you can either pay out the employee for any unused time. And if you pay out for unused time, you don't have to carry anything forward. If you don't pay out for unused time, then you do have to allow for a carryover, but they capped carryover. Carryover is now capped at 72 hours if you have 11 plus employees, or 40 hours if you have 10 or less employees. Okay, so the annual usage amount is capped, and that carryover amount is capped. So usage in a given year, regardless of how many hours you accrue, if you have 11 plus employees, an employee can use up to 72 hours, assuming they've accrued at least that much. If you have 10 or less employees, they can use up to 40, assuming they've accrued at least that much. And then the carryover mirrors those same numbers. So in an accrual system, you have to allow for carryover, but it is now capped. Or you could choose to pay out for unused time if you didn't want to allow for carryover. So a couple changes there. And then the record keeping is the same here. You'd have to track hours worked, hours accrued, hours used, and you'd have to keep those records for at least 3 years. Okay, so that's the earn as you go model. Now I'm going to talk about a front-loaded model, and this was spelled out much more clearly in the revised ESTA language. So a front-loaded model is where I figure out how many hours you would have gotten for the entire year, the 12-month period that I'm defining as a year, and I give you all of those hours up front at the start of the benefit year, and then you have the remaining 12 months to use the time. So in a front-loaded model, for your full-time employees, you can front load the annual max and be done with it. You don't have to do this math of like, well, how many hours do I think they're going to work this year? Okay, 1 for every 30. Okay, what's that number? For full-timers, you can just simply take the annual usage max, which if you're 11 plus employees is 72 hours. And if you're 10 or less employees is 40 hours. You can take that number, put it in their bank at the start of your benefit year, and you're good. You don't actually have to track accrual for your full-time employees, okay? For your part-time employees, you can also front load, but it's slightly different. For your part-time employees, you do have to do the math. You have to figure out about how many hours you think they're going to work in that benefit year. And because this is fairly new, you might be able to look at last year's numbers to get a feel for it. And then you do that 1 hour for every 30 worked, right? Calculation. And that's how you're going to figure out how many hours for your part-timers you're going to put in at the start of the benefit year. But because it's based on an estimate, throughout the year, you're going to have to just run that calculation a few times and make sure that the amount you put in at the start is keeping pace with the hours that employee is actually working. And if the employee is working more than you anticipated and therefore should have had more hours sitting in the bank, then you have to make them whole. You have to add those additional hours to their bank. Okay. So that's the part-time piece. Something that's different on the front-loaded system is that you cannot have a wait period for use, for access in the front-loaded option. So if you're going to give the employee an entire year's worth of PTO at the start of the benefit year, you can't make them wait any amount of time before they can start accessing that bank. Okay, so that's different between accrual and front-loaded. Another idea here around front load, and this will happen, it'll probably happen this year because almost none of you are going to pick February 21st or October 1st for my smaller employers as the start of your benefit year. Most of you will have a benefit year that aligns with calendar year, fiscal year, anniversary year, something like that. So when you have somebody that's entering this benefit, becomes eligible for this benefit midway through a benefit year, you are able to prorate. Okay, so for example, if your benefit year was January to December, and all of a sudden all of your employees became eligible for earned sick time on February 21st, basically 2 months into the benefit year, I don't necessarily have to give them 72 hours of time, or 40 if I'm a small employer, on the 21st. I can prorate that and say, we have 10 months left. If I take the 72, let's say I'm a large employer, my annual max usage, I take 72 hours and I divide it by 12 months in a year. It's basically 6 hours of ESTA time a month they'd be getting. Well, they missed 2 months already because they're joining the end of, February. So I have to load the remaining 10 months worth of ESTA time on the 21st if I was going to front load. So roughly 60 hours, right? If you're doing 40 hours as your max, you just do the math, okay, with 40. But it allows you to prorate. Or if an employee, you get this up and running and it's 2026 and you have a new hire that joins you, in June of 2026, you can still front load for that new hire, but you'd only front load kind of the 50% of their annual amount because they're joining in June, not in January when your benefit year started. So that's kind of how proration works. You are able to prorate with the front-loaded bank. A nice thing with the front-loaded option, yes, you don't have the wait period piece, so that's kind of a bummer for your new hires if you're not quite sure how they're going to do with their time off banks. You're a little nervous about it, but the nice thing with front loading is you don't have to allow for carryover and you don't have to pay out, right? Again, there's no requirement to pay out under either system, but in the accrual option, if you don't pay out, then you have to allow for carryover. In the front-loaded option, you don't have to pay out and you don't have to allow for carryover. It can simply be use it or lose it, because remember, you're going to fully load that bank again at the very start of the next benefit year. The annual allotment of hours is the same in terms of usage, 72 for large employers, 11 plus, 40 for small, and no payout provisions, as we've talked about. There is language in the revised law that allows you to recoup for used time that wasn't technically earned at the time of separation. So for those of you using a front-loaded system right now, you kind of know what I'm talking about probably. Let's say I front-load an entire year's worth of time off in January of the year with the assumption you're still going to be employed with me through December, but you leave in June. So technically you've only earned half of the amount that I put in your bank, but you used all of it, right? But when you leave in June, you've used more than what you would have technically been eligible for at that time. I can true up. I can try to claw back that overage that you used but weren't yet entitled to. I just have to do it within the provisions of the law, which means I have to have a sign off at the time of the deduction, and I can't take you down below minimum wage when I make that deduction, but you can still try to recoup that overage time. And then on the tracking side for front load, you get out of one tracking requirement for your full timers who you're just, front loading an entire year's worth right at the start, either that 72 or 40. You don't actually have to track accrual for them because you just put the annual max in. For your part timers, though, you are having to kind of track that accrual to make sure that you guessed correctly at the start of the benefit year. In both systems, you have to track usage, and in both systems, it's that 3-year look back period. Okay, that's accrual versus front loaded. Now, I get this question a lot. Can I have both? Can I have both an accrual system and a front loaded system? And the answer is yes here. Now, I know for some of you, you're watching this and you're like, boy, one of them seems complex. Why would I want to have two of them going? Maybe I just want to pick one. Well, what some organizations are doing is they are having an accrual system for their part-time employees because they have to track it anyway, and a front-loaded system for their full-time employees. Some organizations are doing accrual for non-management staff, front load for management. Some folks are doing accrual for first-year employees. No matter, exemption status or title, they're doing accrual for your first year because it's earn as you go, and because then I can have the wait period. And then when you hit the start of the benefit year following your 1-year anniversary, then I flip you to front load. Okay, so just a few options there, but you can have both systems running at the same time if you want. And now let's talk about PTO. So many employers that we work with are already offering some sort of paid time off benefit. And the question is, if I'm already offering a paid time off benefit, can I just use that to comply with ESTA, or do I have to create a whole new bank of time? Well, the law, both the original version and the amended version, never said you had to create a whole new bank of time. However, the original version of the law was problematic because what it said was, if you're going to use an existing bank of time and you want it to count for ESTA, then that bank of time has to meet all of the provisions and be subject to all of the compliance requirements of ESTA. And that was really restrictive for employers. And so for a lot of them, it didn't make sense to subject all of their paid time off to those very restrictive rules. So many organizations were going to carve out ESTA, make it its own standalone sick bank, and sort of level set the amount of PTO they offered to make up for the difference, just so that they could keep the rules straight. Okay. Well, the revised language made using an existing paid time off benefit for the purposes of ESTA compliance much more workable. So I'm going to go through some of those now. So the first is, we're going to talk about usage provisions that have changed, carryover requirements changed, payout provisions changed, notice and call-in procedures changed. So as I go through these, I want you thinking about, if you have an existing paid time off bank, how many adjustments might you have to make in order to just have that be your bank, and then you'd be in compliance. So let's talk about protections right now. So if you have a combined time off bank just called PTO, and an employee can use it for whatever they want, vacation, sick, personal, right? You don't care. And you give at least the minimum amount of hours in that bank that ESTA requires. So if you're, a large employer, you've got at least 72 hours sitting in there for your full timers. And if you're a small employer, you've got at least 40 hours kind of sitting in there for your full timers. Okay, so let's assume you've got the hours piece squared away and they can use it for anything. Now what the law says is that the employee has the sole responsibility for telling you when their absence is ESTA related. Right now, if you have a PTO bank, folks typically just ask for the day off. They don't tell you what it's for because you don't really care, right? It's all in one bank. Now you might care, even if it's all in one bank, because if the absence is for an ESTA-related reason, it gets the ESTA protections. The ESTA protections don't apply to every single hour in the PTO bank because many of you are probably giving more than what ESTA requires you to give, but they do apply to ESTA-related absences. So the employee has to tell you, even if they're using PTO, when the day is for an ESTA-related reason. And you can do that a lot of ways. You can, if you're using a paper request system, you can just simply have a box that says PTO and a box that says ESTA, even though they're all in the same bank and you're calling the whole bank PTO, they can just check when they want it to be considered ESTA, okay? Or if you're using an electronic system, you could potentially have them type in the notes section that this is ESTA, and that's all they have to say, okay? But the employee has to tell the employer when it's ESTA. The employer is not just supposed to assume that it is, okay? But now here's some changes. Let's say I give the employee 80 hours of PTO. They can use it for whatever they want, and that's well and above the minimum amount I have to give for ESTA. So I've got 80 hours sitting in that bank. And the employee, because it's their choice how they want to use that bank, they decide to use all or most of that 80 hours for all sorts of things, none of which are ESTA related. They go on a cruise, they're volunteering at their kids' school, whatever. And they don't really have any PTO left. And then all of a sudden they have an ESTA related absence. Do I, as the employer, have to give them more time because the ESTA related absence is now there and they haven't technically used all 72 or all 40 hours for ESTA? They used it to go on a cruise or something like that. The answer is no. So we finally have this clarity in the amended language. The answer is no. If the employee uses all or most of their PTO time for things that aren't ESTA related, that's their choice to do so. But that's all the time they get. You are not required to give any additional time for any absences that might be ESTA above and beyond what you've already given. So it's the employee's responsibility to manage their banks appropriately. If you have everything in one combined bank, you can have different notice provisions depending on the kind of time they need to use it for. So for example, if the employee is choosing to pull from their PTO bank for vacation, you can have notice provisions that say, for non-ESTA related purposes, you need to give us at least 2 weeks notice. And we'll try to accommodate your request, but we might have to deny it if business needs necessitate that you are here on that day. So for non-ESTA related things, even though it's all coming out of the same bank, I could have different notice provisions for my, general PTO type things, and I could deny general PTO requests. However, if the request is coming in and the employee has specifically said that it's for ESTA, then I have to follow the ESTA rules, which means I can't require more than 7 days notice. I can't deny the request, assuming they haven't used all 72 or 40 hours of their time yet this year. So even though it's on the same bank, you can kind of have different rules, again, depending on how they're choosing to use it, okay? Okay. Other things for a combined bank. I'm talking about these notice and call-in procedures here. If it's ESTA related, even if it's all in one bank, and they say, I need to use PTO today, and it's ESTA, then you have to grant the time, assuming they've not used all their annual hours up. And you can either have them, you can't request more than 7 days notice for ESTA. But here's a change. The law used to say no more than 7 days notice or as soon as practical, and then it just stopped right there. And it was like anybody's guess what as soon as practical meant. And many employers were fearful that they were not going to be able to enforce their normal call-in and notice procedures. Under ESTA, it was like a hands-off, very protected bank. The revised law allows an employer to enforce their normal call-in notice provisions for ESTA, so long as two things. One, you still can't require more than 7 days notice, okay? But the second thing is whatever your normal call-in procedures or notice procedures are, they have to be documented. They have to be shared with employees. Employees have to know what they are. If you make a change to those procedures, employees need to have at least 5 days advance notice that you're going to change them. Okay. But assuming you have a call-in procedure that's documented and the employee knows about it, then you are able to enforce that call-in procedure, even for ESTA-related absences, so long as you have a little carve-out language in that policy that allows for mitigating circumstances, right? So, for example, let's say your call-in procedure said you have to let your manager know before the start of your scheduled shift if you're going to be out, okay? And most of the time, that's fine. Even when you're sick, most folks kind of realize they're sick before the start of their shift and they could go ahead and contact their manager. But what if I'm driving to work? I had every intention of being to work on time and I get in a car accident, right? Well, then clearly I'm not going to have been able to notify my manager before the start of my shift because the car accident was this mitigating circumstance and it was unforeseen. And as the employer, you would have to allow me to notify you as soon as possible after the car accident, which might be a day or two later. Okay. So it's okay to have a written policy so long as your policy has a little wiggle room in it for those unforeseen mitigating circumstances. But that's a change. So now, even for ESTA related absences, you can kind of enforce most of your notice and call in procedures, even when it's all in one combined bank. So that's great. And then, of course, for absences that are not specific to ESTA that they're asking for PTO for, you can hold them to whatever notice provisions you typically have. And again, you could deny the request if you wanted to. On the carryover side, again, some changes here that made one combined bank much more workable. Now, if you're using an accrual-based PTO system, so it's all in one bank, but it's an earn-as-you-go kind of system, you do still have to allow for carryover, but it's capped now, which is great, 72 or 40, depending on the size of the employer. Or you could pay out for unused time if you don't want to have carryover. And this was something that a lot of our employers were wanting to do. This is kind of one of the problems with the original language is that the original language required carryover no matter what. And many of my clients like to have this payout provision at the end of the year because they use it as an incentive for folks to be smart with their time. And in other words, if I'm somebody that doesn't get sick very often and I didn't have a big vacation scheduled for this year, if I know I'm going to get paid out for those unused hours at the end of the year, then perhaps I'm not just going to burn through them for reasons that aren't really relevant, just because I don't want to lose them. And for an employer, they're like, gosh, I'd rather have you at work if you're able to work than have you just burn a vacation day because you're afraid you're going to use it. So those employers will oftentimes pay out for unused hours, and that works really well for them. Well, under these revisions for ESTA in that combined bank, or if it was a standalone bank, you now have that choice, right? For an accrual system, you have to allow for carryover with the cap now, or you could pay out for unused hours. And if you're doing a front-loaded system for your PTO, then payout and carryover are both optional. Okay, so that's your choice. Discipline is another issue here. And under the original language, it was real clear. Basically, employers could not discipline for ESTA-related absences under any circumstance. Slight change there. An employer still can't discipline an employee for using ESTA, assuming the employee had ESTA time to use. But employers can now discipline if the employee didn't follow the call-in or notice procedure, assuming there was no mitigating circumstances to why, or if the employer finds out that the employee misused those ESTA hours. So that's not going to really play if you have a PTO bank because you don't care what they use it for. But if you had a standalone ESTA bank that was only to be used for ESTA related reasons, and the person been out for 4+ days, so you asked for documentation on that, and then they couldn't produce it, then in those instances, maybe you find out that they're misusing, you could discipline for that too. The reality is, I think most employers are not really going to know if an employee is misusing their ESTA time because you can't even request documentation until they've been out for at least 3 consecutive days, which means you can't even ask for documentation until day 4. And that's if you want to pay for it. So, yes, it says you could discipline for misuse, but practically speaking, I don't see how often that's going to come into play. Um, and then one other piece here on a combined bank. I know many of you may have policies around payout of unused time at time of separation. I know a lot of the handbooks we write, we will say, if you're leaving us, we will pay out for unused PTO or vacation time, but then we incentivize it, right? If you give us 2 weeks notice, if the notice is in writing, if you work the full 2 weeks, if you turn in all company property in good working order, right? We sort of tie that payout to behaviors that we want to incentivize. And under the original ESTA language, there really wasn't that ability to do this payout option, and now you can choose to have a payout of unused time if you want to. Again, still no requirement that you have to. This is absolutely employer choice. But if you wanted to pay out for unused time at the separation, you could. And if you paid out for unused time at the time of separation, you do not have to credit that bank back if you rehire the person again, right? Because you kind of closed it out. If you choose not to pay out for unused time at the time of separation, again, still your choice, that's fine. But if you rehire them within 2 months, used to be 6 months, but now it's 2 months, then they get access to their previous bank. Okay. I'm going to pause here. I've got a few other questions around updates. I'll just kind of put this on the screen here. But let me pause here because I know we're coming up on time. Alyssa, are there any questions that are coming up in the Q&A that I can answer?
Yeah, we've had a few questions. I've been able to answer most of them, or they were right before you talked about that particular area. But just a couple here, Jody, before you move on. Some are taking this as an opportunity to redo their PTO policy, kind of reshape it and restructure it. So if they are doing that work, do all of those changes need to be in effect either on the March 23rd date for large employers or the October 1st date for small employers? Is that how much time they have to kind of restructure?
Yeah. The law says you have to be minimally compliant, at least with the ESTA provisions, by the effective date, which is the 21st of February or the 1st of October, depending on size. The 23rd of March is when you have to tell people about what you're going to do, but many employers have already had payroll runs that have happened since the 21st of March. So even if they haven't put it on paper and told employees about changes, because payroll was running, they already had to start making some of these adjustments potentially prior to the 23rd. So I think depending on the type of adjustment you're making and how often you're paying your team will tell you how much lead time you have to make your changes. There are some folks that are doing like a kind of a Frankenstein approach for 2025. Like they're just sort of adding on the minimum ESTA compliance just to get them through to the end of the year because maybe they're going to make some pretty wholesale changes, but they want to start that at the fresh start of a true benefit year. So that's an option.
Okay. For those that may have employees that are impacted by the potential exemption of employees that can schedule their own time. So there was a home care provider that asked about that related to their caregivers can make their own schedule. So should they be monitoring Leo for that information? What's the best way to stay up on that?
So good question. I think both Leo and an employment law attorney. Now, Leo specifically in their webinar, which there's a link to on their landing page for ESTA, and that's included in our resources link too that you'll all get. I think specifically gave home health care as an example and said it wouldn't be covered. Yeah. So just watch it carefully, but they're going to make that very, very narrow.
Okay. And then I think I knew the answer to this, but just wanted to double check. So someone asked if they had, so they're a larger employer, 72 hours. Could they front load 40 of it and then make them accrue the other 32? And I assumed it had to be all front loaded or all accrual, but do we know?
So the law says that accrual is the methodology, and that front loading is an exception to accrual. It doesn't talk at all about mixed systems. So my assumption would be it's one or the other.
Yeah. Okay. Those were the basics, and I think everything else you covered.
Okay.
So if folks are on and you still have a question that that you'd like answered, just feel free to keep using the Q&A.
Okay, perfect. Well, then I'll jump back in here with the time we have remaining and try to get through the rest of this information. A few additional updates here. Okay, so we know we have to give a certain amount of time. We know they can use it in 1 hour increments. How much do we pay them? If you have hourly staff, then you're paying them their normal hourly rate. It does not include overtime provisions or commission payments or bonuses, anything like that. It's their flat hourly rate. If you have salaried staff or maybe commission staff that are earning a minimum base wage, then that's the amount you would use, their base wage. Or minimum wage. So if you have tipped employees, it's the full minimum wage, $12.48 an hour. It's not the tipped minimum wage. So the full minimum wage of $12.48 an hour. Now I have a couple of clients that are in the healthcare industry, and their providers get paid a percentage of collections. They don't have a minimum base wage. There isn't a minimum amount that they're going to earn for the day. So right now, when you get paid as a percentage of collections only, if you don't work that day and you had no collections that day, you don't get paid for that day. So right now they're getting $0 for days they don't work. Under ESTA, the way it's written, because they don't have a normal hourly rate and because they don't have a minimum base wage, those individuals would default to the state minimum wage. So you could have these highly compensated providers miss a day that they were supposed to be on the schedule for an ESTA related reason. And so of course they're getting no percentages of collections for that day, but they would get $12.48 an hour for the hours that they're missing under ESTA. So it seems a little bit silly, but that's how it's written. And I guess if I compare it to, they're getting $0 under the current system and they're getting minimum wage under this new one, at least something's better than nothing. And then for documentation, we talked about this a little bit. You can ask for documentation to justify an ESTA absence only after they've been out 3 consecutive days. So on day 4 or beyond, you could ask for documentation. Again, if there's an out-of-pocket cost associated with that, the employer would have to pay for it. Leo is still working to define what would be considered an out-of-pocket cost. Are we talking about simply copays and deductibles? Are we talking about gas mileage? Are we talking about lost work time? What's considered out of pocket? So Leo's still needing to clarify that. One change around documentation is that if asked, the employee now has 15 days to supply it. In the previous legislation, it was silent on how long the employee had to get that to you if you asked. And then a few other things we talked about discipline already. You cannot discipline an employee for using ESTA, assuming they have hours left to use, which again is even why in a combined PTO bank, you're still going to want them to tell you if the absence is ESTA. 1, because you have to follow some of those notice provisions. 2, because you can't deny ESTA. And 3, because you're still kind of tracking how many ESTA hours they've used this year, even when it's lumped in with everything else. But assuming they have ESTA hours to use, you can't discipline for usage. However, you can discipline if they don't follow your notice provisions, assuming they comply, right? Or if they're not using the time appropriately. And then a huge one, the big one for all of us, I want to make sure I say this, this is very exciting. Now, if an employee feels like they have been wronged, that the employer is somehow not complying with the benefits or their rights have somehow been violated, their option is to go to the Department of Labor and Economic Opportunity and file a complaint. So the State Department will be the enforcement mechanism for this, as it is with most employment laws. And then Leo, if they get an employee complaint, they would reach out to the employer, they would notify the employer that a complaint has been filed, and then they would work together to do the investigation and come up with, whatever the recourse is going to be. So these investigations are going to be triggered by employee complaints. No longer can an employee go directly to an attorney. So the private right of action was struck from the amended ESTA, and no longer is there a rebuttable presumption, meaning the employer is not presumed to be guilty at the start of the investigation. Okay, it's like everything's equal. You're presumed innocent unless proven otherwise, and the investigation will sort of decide what did or didn't happen and what's going to be done about it. So no more private right of action, no more rebuttable presumption. So huge, huge wins for the employer community. Penalties from noncompliance, just so you can see them. Oh, sorry, I want to look quick there, just so you can see them. Sean, during his update, again, Sean Egan, the head of Leo, said, look, we don't have stables of enforcement agents like just ready to go out and find employers doing it wrong. It's going to be 100% triggered by an employee complaint. And we're going to try to work with the employer to just get them into compliance. So it sounded like they'd be coming at this more from an education perspective first, assuming that it wasn't the first time, that this is the first time you've been cited and it wasn't egregious or malicious, rather than coming at you with the sole purpose of slapping fees on employers. So that's a good statement. Implementation considerations here. Just a couple of things. I think all of you are probably joining this webinar because you're trying to figure out how to adjust your current systems to be in compliance. So to do so in a way that is minimally disruptive to you, to your team, the least expensive, et cetera. So you really kind of have three options here. You can keep your existing PTO banks if you have them, and just make sure that the hours piece is adequate. Maybe adjust your notice provisions a little bit, decide if you want to accrue, front load, some of those kinds of things. But basically just take what you have now and try to make some minimal improvements perhaps to get it into compliance. The other option is if you have separate banks of time right now, vacation and sick, you could convert your existing sick bank to be ESTA compliant. And if that means that you have to add hours to it, then potentially you are taking hours from the vacation bank potentially, right, to just kind of make them even. That's not something that employees really love, but that's absolutely an option for you, because anything other than ESTA is an employer choice. You're not obligated to give any paid time off above and beyond ESTA. So if you choose to do so, you get to write the rules around how those other systems work, and you can change those rules at any time. So even if you had a previous policy where people got 2 weeks of vacation and 3 sick days, and now ESTA's come into the picture, so you're going to have to add maybe 6 sick days to your sick bank to get it up to compliance. Well, then maybe instead of 2 weeks vacation, you're getting 1 week of vacation, because I'm dropping vacation down to account for the fact that I added more on the sick time. The law allows you to make those adjustments in real time because you weren't obligated to give it in the first place. And then the third option is the carve out. This is if you had an existing PTO bank and you wanted to separate out vacation from sick. This actually was the recommendation prior to the amendments for ESTA. This is kind of the push that most of us were giving to our clients that had PTO banks, was carve them out and separate them. But now with all of the amendments that we went over, I don't think that's necessary anymore. And certainly employees like having all of it in one bank because they have maximum flexibility, and you're out of the middle on that. So I don't think the carve out is as necessary as it was previously. Anytime you're looking at changes around a benefit, you always want to consider not just the financial cost of offering the benefit, but you also have to consider how many days or weeks can I truly afford to be without this person at work? And what is the impact going to be on employee morale or my competitiveness? How am I going to message this to my team? So you've got lots of things that you're considering when you decide which adjustments you want to make and how you want to make them. Okay. And then again, figuring out your method of awarding. If it's accrual based, I've got several items here. If it's front loaded, right, some decisions that have to be made on this side. And as a reminder, I will share these slides with all of you after the presentation so that when you're kind of deciding between one or the other, you can weigh pros and cons, or if you think you've made your decision, you can just quickly go through this slide and make sure you've checked each one of those boxes. The systems piece, this has been a recommendation of ours from the very beginning, which is figuring out which systems you're using right now around time off and timekeeping. If you're tracking this on a spreadsheet, now might be the time to shift over and look at a timekeeping system that integrates with your payroll so that you can set up some of these accrual or award methodologies on the back end so that they calculate automatically. I do think you have to think about the labeling of time, even if you're combining everything into PTO. I think you still have to, because the onus is on the employee to tell you when the absence is ESTA related, even if it's coming out of a general PTO bank. So you're going to want to think about systems for how they would notify you of that, how you would label it on your end so that you could pull those reports around accrual potentially or for certain usage for that 3-year span. So there's still going to be some tracking and systems work that has to be done here in order to make compliance a little bit easier. Obviously, updating policies is a big one. We've created several templates for policies. We have a sample time off policy, both an accrual version and a front-loaded version on our website. Take a look at your call-in procedures and make sure that if you want to enforce those, they are ESTA compliant. Take a look at some of the rules you have around discipline and bonuses. So like if you have a point system right now around discipline for attendance points, you can't apply points to ESTA related absences, even when it's coming out of a general PTO bank, because again, you can't discipline for usage. But the other side of the coin is true as well. If you have perfect attendance bonuses that you're giving, either in the form of additional vacation days or a cash bonus, you can still have those, but you can't count ESTA absences against someone's perfect attendance record, which sort of defeats the whole reason of having one in the first place. So you kind of got to look at both the carrot and the stick on that. And then the notification piece, right? This is what Alyssa was referring to when she said March 23rd. For those of you that have 11 plus employees, you have to be, in compliance with ESTA as of the 21st of February, but you have until the 23rd of this month to notify staff in writing of how you're going to comply. So you have potentially a couple weeks here to kind of get that all sorted out. We have a sample notice letter on our website as well, both a notice for an accrual version and a notice for a front-loaded version, if you want to take a look at those and use those as jumping off points. The change here is that, and we had these notices on before with the previous version of this act, but there's an update to the last thing that the notice has to state, which is that they can contact Leo if they think their rights have been violated. Previously, we had to tell them they could go to an attorney and sue us, which is like a terrible thing to put in writing, but that's what it said we had to do. Now it's a little bit different. So making sure that we've got those notifications. This notification is going to go to all of your current staff by the 23rd of March, assuming you're a 2/21 effective date. If you're a 10/1 effective date, then you have 30 days from that date to get notice to staff. But you're also going to give this notice to any new hire you have from now until the end of time. So this should become a standard part of your new hire paperwork, okay? And then certainly employment law posters are going to have to be updated, handbook language updated, right? So several things here. And then that resources. So I'm going to end with resources. This QR code will take you to our website. And you can join our email list if you want to. I send out updates on this and all sorts of HR related things. We have a video coming out tomorrow, actually a 25-minute long video on compliance. So if you have folks that weren't able to attend this webinar, if you join the email list, you could always share tomorrow's video with them. The templates that we talked about, those are on there on that tools link. So I'll send a master list along with the slides from this presentation to all of you at the end, but this is just a good way to kind of stay informed, okay? So with that, we're right up against the 1 o'clock deadline. Alyssa, I don't know if there are any other pressing questions that came in that you want to speak in for anybody that has time to stay on for just a minute longer.
Well, I answered or responded to everything that folks said. There were some questions about legal interpretation of some things versus Leo's guidance, and kind of who to follow. So I assumed, correct me if I'm wrong, Leo is the enforcement agency, so you should keep an eye on what they're saying. And of course, your attorney would be reviewing that as that comes out. But then, take your attorney's guidance, but making sure that the Leo information is shared and being looked at.
Yeah, so now that Leo is the sole enforcement agency behind this, I would put much more stock in what Leo is saying. Previously, when you could go to an attorney or to Leo, right, and you could file a civil suit in court, or you could go to Leo, that bifurcated approach made Leo's guidance like good to know, but not necessarily the final word on it, because maybe a court would interpret it differently. But now that Leo is the sole enforcement agency, I think Leo's your starting point. And then if you need help interpreting what Leo says, you can always reach out to your employment law attorney.
Yep. So I think that's about it, because I've responded to everything. I'm sure there's probably always questions, but a lot of people have asked about the resources, and you shared it, and I also put it into the Q&A several times.
Okay, sounds good. Nate, anything to close this out?
No, thank you so much, Jody. Thank you so much, Alyssa. This is a topic that I think is probably confusing on its best day. And so to have some clarity there is very much helpful and very much appreciated. Thanks everybody for joining, and hope you have a good day.
All right, thanks.